Hey, it's Mark here, and welcome to the next edition of the Employee Survival Guide, where I tell you, as always, what your employer does definitely not want you to know about, and a lot more. Hey, it's Mark, and welcome back to an edition of the Employee Survival Guide. Today's topic is the hidden dangers of using AI to predict your employment discrimination case. In today's world, employees can turn to artificial intelligence, AI, for almost anything, even legal advice. Some employees are beginning to use AI tools to, quote-unquote, predict whether they have a strong employment discrimination case. Employees are tempted with the immediate feedback that AI provides in analyzing their legal cases. We have recently seen employees who conducted their own legal research and put together what they believe are the correct legal citations, mostly statutes and prominent U.S. Supreme Court decisions, along with their own legal analysis as to why they have a case of employment discrimination and retaliation. This is their pitch to employment lawyers, like myself, to review their cases, or they're actually filing it with the state and federal and city agencies regarding their claims of employment discrimination, hostile work environment, and retaliation. This topic came up because I receive quite a few of these type of emails where people are trying to pitch a story to me. And they, no fault of their own. I mean, AI is out there. It's new and novel, and employers are using it, of course. But people have access to a Google notebook or a ChatGPT or something. And the technology itself is relatively new, and it's based upon what you fed into the system. And so when I read these emails and they give me the cut and paste of what their research was, and we all know what this looks like. It's like this chat or this AI type of production of work product that it looks like it's usually a list, or that's kind of stale. It's not very emotional. It's just matter of fact, whatever. But it's only based upon what the AI device has captured in its learning. And the funny thing about this topic is that the AI devices, these algorithms, can pick up information related to agency websites and devour that. But the case law material, the case decisions from our courts, state courts, federal courts, they're not readily accessible, and they're behind paywalls where you have to go in and access it. Now, there are cases reported out there that there are various websites that put it out, but the vast majority of case decisions are locked behind paywalls for websites called Westlaw and LexisNexis. And so the AI devices that the employees are accessing don't have that wealth of depth. So that information is missing from its analysis. Now, this is a technology in infancy, so you can imagine that if employees are putting together their case analysis today, it might get more robust as the technology increases, maybe what they feed into it. I would love to see the AI devices, like a ChatGPT, have all of the case material decisions going back, let's say, just give it 10 years. I mean, these devices can learn, the machine learn very, very quickly. So why would you put that information into the AI device so that employees could access it? Because the employees would basically be able to read public court decisions, because courts are public, and read these decisions and decide for themselves if they have, a case or not. Remember, lawyers are not the only parties that have an angle or the access to the law. Everybody has access to the law, and at least that's my opinion, and that's why I try to put the slant I do on these podcast episodes. I give you case decisions. You can hear about it. So having employees accessing case decisions is really uber important to leveling the playing field between employers and employees, which is not even, which is uneven. The whole at-will debate you hear about me raise all the time. So back to the point of employees trying to figure out their cases before they confront a lawyer or file before an agency, and they're doing their AI research. I'm not saying don't do this. I'm saying just do this with the eyes wide open about what you're looking at. And, it's okay to begin to learn like a lawyer. And this podcast is really designed to kind of tell you some pitfalls, but also tell you, approach how do you approach it to do it better? Um, how do you take your AI research and create it in such a way that it's more accurate than it wasn't? So first is, read. Now I got a lot of material on my website, and a lot of podcasts that, talk about it. For example, hostile work environment. Everybody loves that topic on my website and the podcast, and so there's a lot of information about that. But how do you interpret a hostile work environment with respect to a fact pattern that what you're currently going through? So what I encourage you to do is this. Why don't you write out your fact pattern and put it in long form, your narrative from A to Z, chronological order, what happened next, who knew about it, whatever, and write it out. You might want to not include names of the employer and use fictional names of characters because you're putting this information publicly out there into a domain AI device that's learning it, and you have confidentiality provisions of your when you sign up for employment, so you would be careful what you're putting out there. I mean, it's like the black hole, this AI device. So just caution you, just write a narrative of facts and then put it into the algorithm, the ChatGPT, and ask it to assess based upon, let's say you live in New York City, and you say, AI, ChatGPT, why don't you assess it under New York City law, human rights law, New York State human rights law, and Title VII, 1964 Civil Rights Act in New York State. And let's see how that ChatGPT device pushes out the outcome. Now, we can't trust what it's going to say, but hopefully if you're using your fact pattern, you might get a closer vantage point to illegality. Sometimes when I do the searches on ChatGPT, I'll get warnings that they're not a lawyer and they can't make legal or give legal advice. You might see that as well. But play around with it, and you might be able to come very close to, let's say, your fact pattern directing you to the conclusion that you have a hostile work environment. And everybody knows what a hostile work environment is. It's a pervasive use of discriminatory comments or comparison of you versus others and that are receive more favorable treatment. It's typically in a sexual connotation, or sometimes it's in a racial connotation where you have pictures of nooses for a racial case or lightning bolts for the KKK or some pervasive, hostile, extreme situation, which is, and maybe the computer can spit out that assessment for you. So go through that exercise, but begin to learn more. If you spend the time, you can figure out that there's information out there. And I'm going to tell you this, write the next ChatGPT search should be, give me notable, let's say, New York's Southern District of New York cases in the last 5 years involving hostile work environment related to sex, and see what those decisions come up with. And let's say you get 5, 6 decisions, and you push those case names back into a Google search and see if you can come across like a Cornell decision. They have a website that has case decisions. Justia is another site that has PDFs. You can read the actual decision, but use the devices, the search in a way that you use ChatGPT to identify cases. You can use a variety of sources to identify cases on sexual or hostile environment in the Southern District of New York. It's a federal court, and see if you can find the cases themselves to read through them. What you're trying to do here is read through the narrative of fact in the decision, but then also look at the court's analysis of that. And that's where I really want to bring your attention. What's wrong with the AI use by employees today is that the employees don't have any understanding of the analysis as it relates to being a lawyer and giving the assessment. Now, I'm not saying that employees have to become quick off the cuff attorneys to identify their cases. It's much simpler than that. I think you have the ability to look at, here's what a case decision is from a judge, and says, here's here's the law I'm applying to this narrative of this case decision you just found using research. And you can see how the judge moves through that analysis using the fact and then applying the law to the fact to establish the conclusion. Well, there you have it. You've just gone to law school. You've learned what the facts are, you've learned the law part of it, and you've learned the analysis of fact and law. That's called issue spotting, or I don't want to give anything to law school. It's this looking at facts, looking at the law, seeing how the facts apply and how the law may apply. And it's a very generic way of looking at, the strength, weakness of a case. Now, you would have to see a lot more of those cases to decide, well, do I have a case or not, or is it how strong it is? I think you're better off running a fact pattern and using your research, saying, okay, I found a sexual harassment case with a hostile work environment analysis by, Judge, so and so, and I put that into my analysis. And maybe I'm going to search further because I want to find some more cases. And here's a trick: once I start to find a commonality of case decisions about the same thing in different court cases in the same district, let's say the Southern District of New York, which I'm admitted to, I stop and I realize, okay, I have the basic foundation of what sexual harassment, hostile work environment is for the Southern District. And you want to move further into the analysis of, and you look at possible other claims that might exist and use the case decision you're reading or researching to identify more cases. Now, I'll give you a cheat, okay? Employment discrimination cases fall under the protected category, okay? And it's age, sex, whatever, race, religion, national origin, disability. And, if you're by and large, you're going to fall into one of those buckets, or retaliation or whistleblowing. And you want to do that search by those different categories of discrimination to find cases that are applicable to yours. Now, you're not going to find the exact case applicable on point, they call it. That takes a little bit deeper dive into the case law, spending hours trying to locate cases. But you're going to get a quick assessment using AI, using Google search, using Justia, the website, to locate cases to read. You have to read this stuff. Don't expect ChatGPT to push out the analysis for you like we're used to, because that's not the way it works. What are you missing? You're missing the subtleties that the law is. You're missing the subtleties to which an employment lawyer will give you, but I think you can come close. I think you can educate yourself about the laws, because I've seen clients do this before AI got involved. I've seen clients go and do the research at law schools and law libraries, and they came pretty close to what the actual analysis is. So there's a lot of commonality of case claims that you can pick up very quickly to put in. I know that ChatGPT will push out, here's what sexual or hostile work environment will mean, and you'll start to, because you put it in several times, you get the same answer. That's not the case. If you actually read a court decision by doing your deep dive research, you can actually figure out how the courts are, laying out the elements of the claim for hostile work environment. Then the next stage of that is, well, just step back and look at your fact pattern in the analysis and see, are there inferences in your fact pattern that support the possibility that you have a claim of hostile work environment discrimination. We're looking for strong inferences. So we're going to take there's two types of evidence here. There's direct statements. We don't like you because you're an F and whatever, and they start to do extreme things in the office, and there's just hostility, whatever. And then that's all direct statement stuff from a boss. And then you have this, and that's like 5% of the cases. So it's out there, but it's smoking gun evidence, and it's not really what you're targeting. You're targeting circumstantial evidence. It's how you're treated differently than other people who are treated more favorably, who are the different categories. So if it's sex hostile work environment, you're looking at, and you're female, you're looking at someone who's a male who's treated better. And you want to do this compare and contrast assessment in your own fact pattern, looking for inferences of how they're treated differently. I mean, that's really where the part of I want you to pick up on, look at ChatGPT, get your data, your information about what the law is, do some additional research to confirm you're correct, because AI is not perfect yet. Get an understanding of working knowledge of what hostile work environment is. Look at your fact pattern and then begin to do your analysis. I think five things stand out. Five circumstantial pieces of evidence point out of compare and contrast, and I was fired because I didn't receive the same treatment they did. Let's not make it complicated, okay? Put your facts together, do your research. What's going to happen to you is when you do your research and you spend the time reading like lawyers do in these cases or listening to a podcast about hostile work environment on my podcast, you're going to begin to become familiar, like with anything, the subject matter that you're working with. And you'll start to see the nuances of things. You'll start to see things pop up for you factually that you may want to put back into your narrative. Spend some time. Don't just shotgun the approach of saying, here's ChatGPT, I'm going to put my information and bang, I'm going to send that to the lawyer. Okay, I'm not kidding. That does happen. It irritates me. What I'm trying to say is you can figure out and come pretty darn close to what your case is if you go about this process of assessing what lawyers do. They ask people to write the fact pattern, write the narrative chronologically. Don't provide conclusions. Just state the facts, ma'am. And then do some research and understanding what this is. Because if you're going to ask a lawyer, to take a case on contingency, which is even worse, you want to be convincing. And if you're not convincing in your initial, email, it's going to take about 2 seconds for me to realize it, and I'm gonna basically dispense with I'm not going to write back to you. I'm just going to say that's not a case I'm interested in spending my time on. If you're going to hire a lawyer on an hourly basis and you're throwing your own money at it, you want to know that you're, hiring an employment lawyer and you're spending your money wisely. There you become a collaborative effort with the employment attorney. And I've seen clients who are bright and they're pretty savvy and they can, they work in a kind of a collaborative effort to push along a case and they understand it. And so you can aid yourself in the process of understanding the legal services you're receiving and understand your case. But if you go about this aspect of the strategy of pushing things into ChatGPT, it's going to be met with false left and right red flags. People pick it up pretty quickly. Employers and their counsel can read it very quickly, say, oh, that was obviously AI produced, etc. So people are doing that, but here's the things to avoid. So get down to the nitty gritty. And it's, when you're creating your narrative and you're doing your research and you're, going the extra mile to figure out what is and is not sexual harassment, hostile work environment, be aware of the following issues, okay? AI oversimplifies the law. Employment discrimination is complex, fact-specific, and constantly evolving. Now, I told you kind of the basic primer of how do we look at these cases in terms of your claims, because I'm doing that deliberately. I want to dumb it down because I want to make it more accessible to you. The law has a tendency to make it really complex, but I'm trying to, make it easier to absorb. And there are a lot of commonalities amongst claims, and you can only see that when you look at it long enough, experiencing it. So AI tends to be applied broad, rigid rules, missing exceptions or subtleties that I would understand as an employment lawyer, and they are exceptions that might make or break your case. I'll give you an example. So you have a claim, you are 366 days since you were fired, and it's and you decided finally to do something about it. What you don't know is that when you filed your USC charge, you were a little bit late because the statute of limitations says 300 days. So you wouldn't know that. So that's an exception. So just AI oversimplifies the law. So be very, very careful.
Let's take a quick break.
Hey, it's Mark, and we have a new product for you. It's called the Employee Survival Guide, or employeesurvival.com, and it's a site that you can obtain PDF products that I've created myself. I was spending too many hours, way too many, researching and writing about, for example, the performance improvement plan or beating them, and the second one about negotiating severance negotiation agreements, two of the most important topics that we see in terms of the web traffic and podcast traffic we have. So check out employeesurvival.com. and see if this can try to help you, and you don't need an attorney to use it. Thank you. Next thing is wrong predictions, wrong decisions. I start this off with the famous set of cases that came out of the Southern District of New York. This involved lawyers. It's a true story. It was reported in the press. Two cases of lawyers who were before the federal judges in two separate cases, both had conducted AI research on legal cases, and the judge got a little bit upset in both cases and said, and they were sanctioned because the AI that they were using, whatever that was, had made up case names and made up case decisional analysis, meaning made it up. Whether I don't know what they were using, but both lawyers in both cases got reprimanded, and it's very embarrassing. The judges look at every single citation that we give to them because we're looking at the cases and saying this is supportive of our client's case. So likewise, I'm asking you to do the same thing when you do a research through ChatGPT. Follow up and read the case. These lawyers in that case that I'm citing, the two cases, they did not read the decisions that this research chatbot had created for them. It's embarrassing, but it proves the point that even lawyers could do the same screw-up mistake. So don't do that. And that's an example of non-existing cases and non-existing case decision analysis. So AI isn't trained on your unique facts or the latest court rulings. That means it can give false confidence, quote, I will win the case, or unnecessary discouragement, I don't have a case, leading you to make damaging choices. So AI is in its infancy. Like I explained before, it doesn't have all the thousands and hundreds of thousands of case decisions across the country in its databank because it's behind a paywall. Yeah, you're like, well, that's unfair. Why is that? Why courts are open? Why can't we access it? Well, it's a larger question. I think that we should have access to all the case decisions in both state and federal courts. But maybe there's a reason why that's not the case, right? Because more information is power. The more power you have, the more damage you can do on a corporation. So maybe that's the case. There's also Westlaw and Lexis who provide the services, and I pay a good dollar for that service. My lawyers, myself. The next item for what AI is not to be trusted is missed deadlines and lost rights. Like the example I gave you, if you come up with hey, I want to file an EOC case 365 days after the adverse action, meaning you got fired, you're too late. You got to file your decision or your claim to exhaust your administrative remedies in 300 days or within 300 days. So easiest is missed claims because you didn't understand the filing requirements in terms of deadlines. I'll give you a basic primer, 180 days and 300 days on employment discrimination cases, okay? Let's just follow that. So the adverse actions have to occur within that. Most state and federal agencies work on what's called a work sharing agreement, and so you get the benefit of a 300-day window. And I would always encourage you to file with the EOC first and then have the EOC file the claim with the local state agency. So you get the 300-day window time period. The next item is I spoke about before is when you create your written narrative and you put it into the ChatGPT to figure it out, use generic names. Don't use company information that's identifying of the company. When you type your story into a public AI system, you expose sensitive details, names, dates, medical history that you can't take it back. AI doesn't guarantee privacy, and you sign most likely confidentiality agreements with your employers not to share the information publicly. You're putting the information in a ChatGPT or an AI device. You have disseminated information out there publicly. So be very careful because it's not about if, it's about when these systems and employers catch up that they can figure out who disclosed the information. So be generic with your names and company information and what you're talking about. So it can't be disclosed in the narrative when you write it, before you submit it, what your company name is and who the players are. The next item on what ChatGPT or AI devices can't do for you, they can't provide strategy or advocacy. AI can identify discrimination, but it can't file an EOC case. You need to have a working knowledge of the EOC process, which I'll basically give it to you. Go to the EOC.gov, grab the Form 5, fill it out, notarize it, say, see attached affidavit, write your fact pattern, get it notarized, and then submit that. That's your filing of the EOC charge. Anything else beyond that, it's like leave the agency to figure it out, how to deal with it. But generally, they will request mediation, and you want to submit to that. They can't negotiate with your employer. Well, you need somebody to do that for you. An employment lawyer can do that. I have and do encourage people to negotiate directly with their employers, and people do it and successfully do it. It's just simply, you get your severance package, and they say, no, we're not going to revise that. They give it to you in a PDF, and it's intentional. And you basically say, well, here's my fact pattern. I have claims here, and I'm going to try to leverage this and push on you. Make believe to the employer that you have an attorney. You don't have to disclose the name of your attorney to your employer. You can just, if you go through this process I've described, you can come down to a very professionally written thing on your own. You may not just use your affidavit with a Form 5 charge affixed to it, notarize it. You can convince your employer because the facts in the affidavit are the most important. It's not what the lawyer is doing. It's not what I'm writing about. It's what the client says in the fact pattern that's damaging to the employer. And maybe just not disclosing you have an employment attorney and just writing in a very cohesive and methodical and detailed format from A to Z, chronologically speaking, about what the claims were. I've seen clients negotiate for money and close out a deal without having to hire an attorney. And I love that because law is, it should be free and open. Why not? Before there were lawyers, there were just, the law. So, lawyers like to curb the market. I'm saying enough for the guardrails. Let's, open access to everybody. And so you can negotiate with your employer if you try, but just have to basically look at what you're trying to do, think smart about it. The next item, the AI can't represent you in court. So at some jumping off point, you're going to hire an employment lawyer. If you want to file a lawsuit, yes, the courts are set up. The federal courts are set up for you to file a pro se action. State courts the same way. And they will work with you to do that. It's a very simplified approach, but you can actually file your own lawsuit. But you don't want to avoid that because filing means notoriety on Google. You can't ever take it back. It's always there. So be careful. So at some point, you're going to have to step off and hire an employment lawyer if you feel you really need to do that. So next item is hidden claims left on the table. This one's easy. Employment lawyers have a variety of claims in addition to employment discrimination claims, that they are looking at when they're looking at the same fact pattern. It's just by experience. And so if you don't use an attorney, you're not going to get that analysis to help your situation, and you're going to leave the claim on the table. The employer will see it because they know about it. The employers know what they do. If you don't clue into that aspect, they know exactly what they're doing. They want to see if you know. And if you're better at spotting the issue and seeing what happened, that gives you leverage. And that narrative can spell out that you do know what they did. That's what the narrative does. It has to do that. The other aspect of AI, whether it comes in your own individual research like this, but AI reinforces bias. AI relies on historical case data. It may undervalue claims by women, minorities, or other groups who already face systemic underreporting. The result, bad predictions rooted in past injustices. Now, AI, I don't know if it's smart enough to realize, claims that case decisions that occurred a long time ago. It's not, whether it's using current information. I don't know how they train it, but you don't believe the presumption that they did train it correctly because you have no idea. I don't know of a product that's out there yet let's provide AI related efforts to case decisions to help employees like yourself. I don't think that exists. I'd love to create that to harden your skill set with knowledge based on cases. If you want to dive into it, you can, like I said before, you can research using ChatGPT. You can go to justia.com and find reported decisions. There are other sites that provided reported PDF decisions for free of charge. But the AI reinforces bias issue. That's the whole argument that humans created the machine learning, gave it what its source data to absorb, but there's inherent bias built into what it's reading. The other part of a bias has to do with algorithmic interviewing. There's some recent cases we've talked about before, where the programming itself, the actual coding is biased in some way, and there's some court decisions, some cases currently ongoing right now. Emotional blind spots. This issue has to do with if you're going to go all the way, or to any extent with your legal case, it really is about the issue of, handling your emotions. People don't understand this, and they get tripped up really easily, and I have to redirect them back to center. AI, when you're researching and developing your case, it gives you cold technical answers. I mean, it's not saying, oh, "I'm sorry this happened to you." And I've seen other examples where AI has gotten more emotionally connected to the user, and that's kind of a development I'm seeing. And I guess the more it knows you, it can get more predictable. It depends on what device or AI device you're using. So you're trying to navigate the issue of your employment discrimination case with your employer, and you got a lot of fear, anger, anxiety about what they're doing to you. The same goes when you hire me as an employment lawyer. It's very emotionally charged. I mean, you name it, I've seen it. I've seen great people go through the process gracefully, delegate to us to do something, manage it, and they understand, and they're managing, and they're managing our expectations. They're communicating fine. I've seen then the opposite continuum where people are just over absorbed with their anxiety about what happened to them, their own personal issues. I mean, this truism that I know why you got fired when I interact with you over a period of time or look at your cases, I can see why your employer fired you. If you don't know that, that you may be exhibiting behaviors that tell others and you can't see it, I've seen it. I mean, this is like 28 years. I've seen exactly what the behavior or why people acted the way they did and they got fired. So you got to look at the emotionality of what you're about to engage, what you're doing currently if you're still working. Take a hard look at it. Don't just assume like you're perfect and you're normal and everybody else is effing wrong and they got issues. So it's something that needs to be checked, and I try to draw people into the transactional analysis of their situation. Like okay, you have something happen to you. Yes, I know it's emotional, but you're going to dump it all down in your narrative. But when you come to the transaction, using AI to navigate, to research and help you research and present your case, you want to do it in a very transactional mindset of, hey, I'm asking for a year's pay here. Okay, I'm using this piece of narrative that I wrote as leverage against the employer, and I'm doing some research here to help me pinpoint that I'm correct and they're incorrect about why what happened to me, and see if you can influence them. Now, I can't help this issue. This one issue is that if you show up at the table and there's no reference to who your attorney is, you might get called out on it because the employer is expecting to see your attorney show up. And you have to, you have to fluff this one. You have to say, well, I'm working with an attorney and, and you're going to go through me directly. The employer is going to assume that you don't have an attorney. And they're going to alter their dynamics that they're negotiating with you based upon that. And I know that sucks, but employers do that. You have to figure out a way to make your narrative very, very convincing based on actual facts and in your research about what's taking place. You may get their attention, and they may want to bury that affidavit that you provided to them in exchange for a settlement of claims. So you're very powerful, and you have leverage to work with. Just slow down. Take a hard look at what you're being offered in terms of your ChatGPT, production results, and think, transactionally about this. Take the emotions out of it. If you're wanting more severance and you think you have a right to claim to do it on, take your time and research things. Maybe There are law clinics and law schools. These folks have students with skills who can assess what you're doing, possibly help you, ghostwrite stuff for you. I've seen this done. I've seen a lot of stuff done. Go beyond just what GDP is giving to you. The AI device is in its infancy, and you need to basically, this is about you and your career and what's happening to you. So if you're going down that pipeline, that rabbit hole of, using AI, this whole podcast was designed to make you say, wait a minute, stop, take a breath, look what you're using, recognize that it's in an infancy state. Um, Learn about cases in your jurisdiction. That's what lawyers do. The Supreme Court case decisions are available for all to see on the U.S. Supreme Court's website. Other case decisions come out of various kind of wonky websites like Justia, but the information's out there. And read about these cases and begin to learn about how law is applied to your set of specific facts, and maybe you might come out with what the possibilities are. Uh, just give you a little further cheat. I'm not going to know the result of every single case that I proposition to an employer in terms of what's potentially might happen. The case might just settle. I never know. There's thousands of cases. I never know the result of what could have, should have been of that case. That's the cheat. You don't really need to know that answer. What you do need to know is, what do your facts say? Forget AI for a second. What do your facts say after you've spent the time learning about what sexual harassment is and what hostile work environment is in the Southern District of New York under New York State law and New York City code, by the way, the premier area to be in, both New York City, Southern District, New York State, meh, but New York City, definitely. And, if you really do your research, you can be a powerful device for yourself in your negotiations with the employer. I've seen it done. And, forget about the future of the case, what may happen in results of what a jury will do. It's not about that. It's about influencing your employer to pay you money before the lawsuit ever gets the light of day. So hopefully that answers something for you. You do have to have a set of facts. Those facts govern the entirety of the case. Take your time. All the information's there. You've witnessed things, and put it together. Make it compelling, but don't make it this drama-infused, thing of what you watch on TV. It's just matter of fact. Just say the facts, A through Z, chronologically speaking. Quote people what they said to you, and go over it and just perfect that fact pattern if you're going to do that. Use AI to help you, but just have all these kind of safeguards that you're going to do your research and double check what you're doing. And if eventually you need an employment lawyer, well, you can always hire one. There's lots of them around. So I hope this helps you understand, using AI from the employee's perspective, some hidden problems with it, but you still can use it as a tool to help you get to where you want to go. And really, in the end of the day, it's just about severance, okay? It's not about getting your justice. And people say it to me, I'm like, I'm sorry. I go about this issue in discussions with judges as well. This is the best we can do, okay, our justice system. And it's really about awarding money to people through negotiations and settlement, okay? Because people, you can't afford the legal process. Unfortunately, it's made it too cumbersome financially to do it. So there's a way we go through this. Even if you go through litigation, we still end up settling cases before a jury trial. Okay, the courts are not. There's very few jury trials. So you understand that. There's more probably in state court, lesser so in federal court. So you do have access to the system in the way I've been describing. You do have tools at your disposal, which I have gone through. You can use AI, but with caution. But it's really, at the end of the day, it's about you writing your facts, and you looking up the law. Maybe you want to go to law school. Hey, here's a shout out to going to law school, okay? It's rewarding. You can help other people like you in the future if you do it. And people go to law school all the time. But understand, if you want to go to law school for employment law, a worthwhile profession. There's more need for them, okay? But lawyers are aging out. More lawyers are coming in. But so employment law is very valuable to help people like yourself. So it's just, maybe your calling. Maybe that's what sparked something here for you and you go run with it. So with all that said, use AI with caution, know the pitfalls, but, do your research. And it's okay. You're not going to get all the answers, but that's okay. And so Hope you found it interesting. I'll talk to you soon. If you like the Employee Survival Guide, I'd really encourage you to leave a review. We try really hard to produce information to you that's informative, that's timely, that you can actually use and solve problems on your own and at your employment. So if you like to leave a review anywhere you listen to our podcast, please do so. And leave 5 stars, because anything less than 5 is really not as good, right? I'll keep it up. I'll keep the standards up. I'll keep the information flowing at you. If you'd like to send me an email and ask me a question, I'll actually review it and post it on there. You can send it to mcarey@capclaw.com. That's capclaw.com.